You can't give yourself 240 hours of community service. All right, that's it.
Ma'am, Your Honor, I was not working there at that time.
Sir, it doesn't exist. Sir, I was born at night, but last night.
Your Honor, nobody's trying to pull anything over your eyes. The organization, when I called.
Why would you go to a place that you incorporated to get your community service? What business, what filings are you doing for a nonprofit that doesn't exist? Why are y'all even giving me this foolishness?
Yes, Your Honor.
Are you ready on the motion to revoke for Mr. Walker?
I am, Your Honor.
Your Honor, may I say something before we get started?
Go ahead, sir.
Okay. If you can recall, Mr. Walker had submitted a application to Cobb County.
And he was rejected. Yeah, I recall.
Now, they said they said that he did not need treatment. Now, I don't quite understand what that means, that he doesn't need treatment.
I don't know what their metrics are, sir. So I don't know what they're measuring, how they're measuring, or what their baseline requirements are for their court, because I don't deal with Cobb County, but you all requested that he be allowed to petition Cobb County to see if they could put him in drug court. If they have rejected him as not meeting the standards that they have, then it's back in our court.
No, they didn't reject him. They just said that he does not need any type of treatment. And
so they were going to let him go through the program, but he didn't need treatment, or they said that he didn't need to be in the program?
No, they did not say that.
Okay, well, sir, that's the way you made it sound to me. So
I made it sound.
I asked what the next option was, and we put it back on the calendar. This is all semantics to me. If he's not going to be in the Cobb County program, then he needs to be here before me, and we need to move the case.
Yeah, well, I agree with you.
So I don't care what Cobb says. It depends on what we say.
Okay. However, Your Honor, if you can recall, we had a contract with the state back in, what's that? November 13th of 21 at 5:14, where they made us an offer. We never rejected that offer.
Sir, that's not what we're here for. We're here for a motion to revoke.
I understand. I'm just bringing some things.
Because you didn't accept the offer before the motion to revoke was filed. So right now, what's before me is the motion to revoke, which, for the record, has been postponed from May 13, 20. I'm sorry. It was filed. It was continued from May 13, 2025, June 30th, 2025, July 29th, 2025, August 5th, 2025, August 19th, 2025. 5 times the motion to revoke has been moved because of a request from counsel. So let's get on the road.
Well, I hate to say anything else and we move on, but however, we filed appropriately our motions, and this thing was filed in April 25th, I believe. I can't see too good there. Of 25, is that correct?
I believe so, sir.
Okay. However, Your Honor, we must state before we get any farther that we did accept the offer from the state. And when we attended a hearing, we said so. And for the record, now we deem that as being a contract between the state and ourselves.
No, there was no acceptance because there was a novation of the contract. The novation was, we wish to participate in Cobb County's program. Give us the opportunity to see if Cobb County will accept him. So there was an offer made, but there was no acceptance of the offer made by Mr. Tipton or the state, because your novation was, let's do it in Cobb. So we gave you the opportunity to explore whether Cobb would accept him. They did, in fact, not accept him. There was no offer and acceptance under classic contract law. What you did was issue a novation. they didn't, Mr. Tipton's office has not accepted the novation because Cobb did not approve Mr. Walker for their program. Now, can we get to the motion to revoke?
We can proceed, Your Honor, but however, we would like to preserve our rights to appeal this.
Oh, you have every right to appeal. I never keep somebody from appealing because I
Yeah.
believe in the constitutions of the state of Georgia and the Constitution of the United States.
Okay.
So you can appeal whatever you want to. We haven't even started the hearing.
Right. Okay, Your Honor, we're prepared to move
This is
forward.
case 2021 CR 08227, Willard Kirkland Walker. A motion to revoke bond was filed in this case. This is for Mr. Walker is charged with DUI less safe and striking a fixed object. He's represented by attorney Nathaniel J. Middleton, who's present. Mr. Tipton is representing the state. Mr. Walker, if I can ask you to move to the side or sit at table. All right, Mr. Tipton, your motion.
Yes, Your Honor, and I am trying to get my chief investigator in here as he did some investigation on this case. But in the meantime, Your Honor, I would like to draw to the court's attention the motion itself that was filed. Ask those be admitted as States Exhibit A and B respectively under judicial notice and self-authenticating documents.
All right, Mr. Middleton.
Your Honor, we are not disagreeing with the days in which these events happened. However, the 2020, we must say that it's been over 5 years today. This is August of 25, and he did receive a second, and we admit to that, DUI within the 5 years. But and he also was granted a bond by the magistrate court judge in which he served under that bond, and he has complied, other than he did receive another ticket.
Okay, so Mr. Middleton, the problem is, while the bond condition that you not get a violation of the laws of the state seems like a throwaway condition. Yeah, I'm on bond, don't do anything else that brings you before a court. Mr. Walker was on bond for a DUI, and it was during COVID, so things slowed down for us. He then goes out and gets another DUI in a different jurisdiction and was adjudicated for that. The problem that I have with this is that Mr. Walker has a chronic alcohol condition, but he won't sit at home and drink and stay home. He gets on the road. If you're already aware that you have a DUI pending, you're on a bond condition for a DUI, and you know that, if I'm not mistaken, he's had a previous DUI sometime in the past. Now, I could be wrong. If I'm wrong, correct me, but I don't think I am. But you don't take the responsibility to understand that you have a previous DUI, you're currently under a bond condition for a DUI, and then you go out and get another DUI. It's not like if you were telling me he got a speeding ticket, I'd be like, Mr. Tipton, this is not necessary. He got a speeding ticket. He got a window tint violation. But the difference is a motion to revoke bond is brought most often to make sure that there's protection for anyone who might be at risk from the actions of the individual. Mr. Walker is a chronic DUI driver. He drives while he is under the influence of alcohol. That is a risk to everybody on the road, including himself. Mr. Walker has tried to avoid the consequences of going to jail for it. But this is the problem. If you're already on bond for a DUI and you don't have enough restraint because you are an alcoholic and you go out and get another DUI, if he was drinking in his house and didn't move, I would never know about this because he would never have broken the laws of the state of Georgia. But he has so little restraint because of his condition of being an alcoholic and addicted to alcohol. But then you tell me Cobb County says he doesn't need treatment. Well, like I said, I don't know what their metrics are. But if anybody needs treatment, I would believe it would be Mr. Walker.
Can I say something, Your Honor?
Sure.
Well, Your Honor, Mr. Walker has been very remorseful of what the situation that happened way back in 21. But however, Your Honor, this is 25, and the requirements that the state gives for his revoking his bond, we question it. They're saying that he would flee the jurisdiction. Mr. Walker has attended all court proceedings, have never tried to flee any jurisdiction. He's been here, he's come when I was not there, when I was ill and could not make
Mr.
court.
Middleton, that's not the reason that Mr. Walker, that the state has brought a motion to revoke bond.
Well, I'm
The
looking
reason
at the
is-
motion.
He's a danger to everybody.
Okay, I hadn't got to that one yet.
Okay, well, let's get to that one because that's the one that concerns me.
Okay.
We don't want to waste my time on surplusage. The
Okay,
stuff
well-
that doesn't matter to me, he's to flee. He's been here every time. I will acknowledge that. But
Okay.
he's a danger to himself and others.
But Your Honor, we admit that he did violate the bond order. And that's because of the dates. You can look at the date and see he did in the time period before he received another charge.
And we would have adjudicated this a lot closer to the time that it was brought, except we had to reschedule it 5 times.
Well, I understand, Court, and we apologize for having gotten sick.
You disgust me. How can you live with yourself? You sit on a throne of lies.
But
Well, I'm not asking you to apologize, but if you're going to make a timing statement, then it's not the timing, it's the fact that it was brought as quickly, this was brought in April. He got a certified conviction April 4th, 2024. This was brought this year and earlier this year, so we could have adjudicated it earlier, but it doesn't change the fact that what I'm concerned about is Mr. Walker being a danger to himself and others. And then when you come in and you say, well, Cobb doesn't feel like he needs any treatment. Well, I beg to differ. I'm not sure why they would believe that because I don't know what they're measuring.
Well, Your
But
Honor, we did.
Are you going to tell me that Mr. Walker is not a danger to himself and others?
Well, Your Honor, he's my client. Obviously, I'm on his side. But however, Cobb County did issue that to us when we applied to the program, and we had, and Your Honor, if she can recall, you did accept him if he could get into a program, and we
did.
And we've done everything we could. So now we're back in this court's arm. Now, is it that this court rejects accepting him in that program? I haven't seen that yet.
Well, you didn't ask. And A, you didn't ask. B, what you asked for was to go to Cobb. Cobb rejected him. You keep saying they didn't reject him. They just said he didn't need treatment. It's semantics to me. The whole point is that now we have brought the motion to revoke bond, and now all of a sudden he's willing to accept what we could have done months ago. Mm-hmm. Because if he can't go in a program in Cobb, it's either going to be jail or a program. I'm going to tell you right now.
We want a program, Your Honor. We said that.
Well, if he's not doing Cobb, it's going to be jail or a program. But right now, that's not where we are. We're on the motion to revoke.
Well, I think what had happened, though, Your Honor, you had sent us to another judge. I can't remember who you sent us to.
For the DUI program. And then you all said you wanted Cobb.
Well,
I sent you to the Clayton County DUI judge. You all said we would like to try for the Cobb program. I said fine. Judge Garrett said fine. You've driven this. We're doing what you're asking for.
Well, I beg Your Honor's pardon, but we were told that it would be most conducive if we were to apply for Cobb because he is a resident of Cobb.
Okay. But we're back here. Let's talk about the motion to revoke.
Well, as we're stating before, we don't disagree with the events that occurred. And that speaks for itself. However, and Your Honor's main concern is whether or not he will be a danger to himself and the community. I think that's what I hear Your Honor saying.
Yes,
Okay, and I'm saying to Your Honor, at this time, we are willing to, and we have participated. He's a member of AAA now, and I sent you some additional things which he's completed since he was arrested, being proactive towards resolving everything. We've taken 240 hours of community service. He's done the evaluation. He's taken the DUI, and we sent that over to you again if you had not seen it. And I'm not saying we're going to hang him today, but he is doing everything within his powers, and he's not received any tickets or anything in the past 4 years. So
except for the DUI.
right, and that was in 21. Say, but he's doing everything, Your Honor, and in fact he has a job now. He's become a very stable man. He was going through a divorce at the time, and job, he was laid off his job, and I'm not asking for sympathy in that sense, but
You won't get any.
but he has not committed any act involving alcohol and the use of alcohol. And we're just asking that he give an opportunity to participate in that program and not revoke him. Although I know the Your Honor, we don't even want a trial. So we're just saying that we accept the burden that we have, and we're asking the court to have mercy on us and allow us to proceed.
Mr. Tipton?
Your Honor, at this point, is the court going to take judicial notice of the documents?
The court shall.
Your Honor, at this point, what we have is we have a contradiction, and the contradiction is that Mr. Middleton's telling us that Mr. Walker hasn't touched alcohol, but we've also got a conviction where he said that he touched alcohol and drove. We're hearing that Mr. Walker was not accepted into the DUI court program. Now, I'm the DUI court prosecutor in Clayton County. I'm familiar with entries into DUI court. I'm familiar with the fact that the main test that they used, the RANT, that's the risk assessment needs test, is highly dependent, incredibly dependent on the answers given by. I'm not saying Mr. Walker wasn't 100% honest, but what I would say is that if he wasn't forthcoming with the number of DUIs, if he wasn't forthcoming with the issues he's had, if he wasn't forthcoming with why he saw it necessary to go through AA, then that may not have given them an accurate result. And in all fairness, it can be embarrassing to be that forthcoming. But that doesn't change the fact that Mr. Walker is a threat to the community. I don't think he's an intentional threat to the community. I think he's a negligent threat to the community. I think that he is being reckless in how he consumes alcohol. I think that he has been reckless enough to where he's gotten a new conviction, which the defense agrees with. There's no contesting the nature, the events that occurred after the bond happened. There's no contesting that Mr. Walker was arrested for DUI. And there's no contesting that it was so serious that they initially sought to put him in a treatment court. Your Honor, this is perhaps the most cut and dry motion to revoke bond I think I've ever seen. And, you know, once again, I'm not doing this out of any malice to the state's not doing this out of any malice towards Mr. Walker, but we are doing it out of concern for the citizens of Clayton County. Because as Your Honor has stated numerous times, the worst thing that Mr. Walker could do is hurt or kill someone. And he'd have to live with that every day of his life. At this point, Your Honor, the state's going to ask that Mr. Walker have his bond revoked, that he be kept in the Clayton County Jail without bond until such time as he can be heard or he enters a plea to the DUI. With that, Your Honor, the state respectfully requests that the court accept, that the court grant the state's motion for bond revocation. Thank you.
Let me ask you one more question, Mr. Tipton. Since I don't have access to his GCIT, how many previous DUIs? What's this for lifetime for him?
If I may, Your Honor, if I may have a moment, Your Honor.
You may.
You want to say something in the meantime?
Sure.
We have here, and I don't know how much experience the prosecutors had over at Cobb County. I have the application here, and we sent a copy to Ms. Ponder of everything. And we even sent her where they said he does not need evaluation. But that's not the argument here. The argument is we feel as if Mr. Walker is somewhat being penalized for having, for COBRA having happened and all the time in between up until now. There's a lot of cases, Your Honor, still lagging.
Bro, what are you talking about, man?
But that's not to say that he was not there. He's attended every hearing, we filed everything, we stood before the court, and we have said that we accept the plea. We accept the charges, and we get the contract with the court, and we have no problem with you going ahead right now and adjudicating it. I don't see where putting him, revoking his bond would make any sense at this time.
Your Honor, I have that GCIC, if I may.
You may.
Thank you, Your Honor. Your Honor, cycle 3 of his GCIC is a conviction for DUI out of Douglas County State Court. That is out of 2018. Cycle 5 is the Clayton County case that's pending. That's out of 2020. Cycle 6 is the Rockdale County case that he has pled to. That is 2021. And Your Honor, once defense counsel has completed their argument, I would like to rebut.
I'm sorry, say that again. He did what now?
Once counsel has completed their argument, I believe the state has a second closing to rebut, because I believe we're in the argument stage now.
Okay. I have a question.
Your Honor, we can't hear you.
Oh, I'm sorry. I have a question.
Yes, Your Honor.
So I see Alliance of DeKalb County, Inc. is where he did his 240 hours of community service.
That is correct, Your Honor.
Except when I look at it on Google Maps, it's a park. It's Flat Shoals Park. 4522 Flat Shoals Parkway. It's a park.
Your Honor, I can answer that.
I'm sure you can. I'm looking at a park with children's equipment, but it says in the letter that you filed documents, bought supplies, you visited properties and other activities as directed.
Yeah.
What's that?
The Alliance of DeKalb County was a nonprofit organization. Its office was 4522 Flat Shoals Parkway. So it was actually office in the community center that's located at that location. There's a tennis court and a small park behind it, but the office was actually at that location. So it is a standing building. It's the Community Achievement Center.
Okay, so I have the Alliance of DeKalb County was administratively dissolved in 2022. I don't have a Myron Gooding associated with it. There's no website. It was incorporated by someone named Walker, Kirk Walker. So that doesn't exist, Mr. Walker.
It doesn't exist at this time, Your Honor.
Who is W. Kirk Walker? That's you.
That was me, Your Honor. Yes, I'm the original executive director. In 2019, I left the organization. So when all
Yeah, but sir, the organization was I'm on the Secretary of State's board. You can't give yourself 240 hours of community service. All right, that's it.
ma'am, Your Honor, I was not working there at that time.
Sir, it doesn't exist. I don't see anything. I don't see a website. I don't see anything with Myron Gooding except that he's a mortgage professional. I don't see anything connecting this to the address for this is 21007 North Decatur Road, Suite 316. Everything else I got is the park. I was born at night, but last night.
Your Honor, nobody's trying to pull anything over your eyes. The organization, when I called.
Why would you go to a place that you incorporated to get your community service when there's so many other organizations out here where you can do community service? Why would you go to a place that I would even question? It's not even active, which means it is not a valid nonprofit because it does not hold a valid place. It is administratively dissolved, which means that that letter ain't worth the ink that's printed on it.
Your Honor, if I may, at that time, I was advised to do the community service by my attorney for this case.
Yeah,
I was not aware that it was
service, but you didn't look around for some place that actually needed community service. What filings are you doing for a nonprofit that doesn't exist?
At that time, the nonprofit, to my knowledge, it was existing. The work that I did was to make sure that the files were in place for the houses that the nonprofit had bought.
This was April 28th of 2022 that you gave me this letter. First of all, it is now 2025. So you want me to go back to an organization that you were associated with and give you credit from 2022 for 240 hours of community service? No, sir, not.
Okay.
Why are y'all even giving me this foolishness?
Well, Your Honor, you can reject that. I understand.
It is rejected.
Yeah, I understand Your Honor's logic in that. But with regards to the other things that we provided to you.
This is stuff he did for his other DUI. All of this is 2022. None of this is current.
Well, if Your Honor,
and if it had worked then, he wouldn't have had the DUI that he was convicted of.
We understand, Your Honor. So we will do the requirements in another program. So now, let's put it that way, since you've rejected those that he's done. Mm-hmm. Okay, we're fine with that. We're fine with that.
Did you have a closing, Mr. Middleton?
Well, in closing, Your Honor, we said we'd like to get the mercy of the court in the sense that we have been actively trying to get the things done. And as we stated before, we accepted the first offer from the state as a contract, and we were in the process of.
I've already told you, the first offer was for the DUI court here in Clayton County. Well, your novation was for the DUI court in Cobb County. Therefore, there was no offer and no acceptance. Okay. Well, at this point, Your Honor, we're stating that we don't see the necessity of revoking his bond when we can take our plea and we can go ahead and move forward with the court's wishes. And this obviously will be a non-negotiated plea, but with some of the things in mind with the state wants. At this time, Mr. Walker is going to be taken into custody. He'll be held in jail until such time as his case is resolved or he has a trial. Well, we've said, Your Honor, we don't want a trial. So I got you. Does Your Honor have any sentiments with regards to what she will be issuing? Okay, this is what was on the table, Mr. Middleton. You were supposed to go into the to the Clayton County DUI court. That was all. We gave you 2 weeks for that. Then you came back and said, well, we want to do Cobb. We gave you another month for that or more. then, I mean, I'm done. I gave you the opportunity to go into Clayton County court. You didn't want to do that. You went to Cobb because it was more convenient for Mr. Walker. They didn't want him. But Mr. Walker's not going to be just traipsing around outside. He's too much of a risk.
Okay. So, Your Honor, as I stated, we will take the sentence here and now, and then allow him whatever the court wishes to do from here. To me, would be the only logical thing at this time.
Mr. Middleton, I'm not prone to do DUI jail sentences for DUIs because most of the time it's a negotiated plea. But in this case, I don't think that Mr. Walker takes seriously enough what's going on. For you to come back to me and say, well, Mr. Walker didn't need treatment from Cobb, but you know his history. I don't think that that y'all are taking this seriously enough.
And that's what we're saying to the court now. And that's why we were prepared to come before the court. But however, that motion to revoke bond was filed immediately the same day when you sent us out to look at Cobb. In fact, I think it might have been filed before.
Okay.
If you look at the date.
Mr. Tipton, are you inclined to have to go forward with the plea today?
Your Honor, I'm forward with a non-negotiated today. I do want to just state that I believe it would be inappropriate for Mr. Middleton to attempt to prod the court to see what the court is inclined to give Mr.
Oh, I wasn't inclined to tell him.
Thank you, Your Honor. State is inclined to do a non-negotiated plea.
All right, you can unhook Mr. Mr. Walker for now. Thank you.
I couldn't hear the last thing you said, Your Honor.
I said he could unhook Mr. Walker for now. Let's go ahead and get the police set
Oh,
going.
okay. So does the state want to put us in a breakout room so they still can make that plea or what?
No, we're gonna do the plea on the record. Why would we be in a breakout room?
Oh, now what is he asking then? That's what so we'll be clear on what they're asking.
Well, in a non-negotiated plea, y'all come before me, you get the plea started, and then he will ask on the record during the plea colloquy what he wants. You will ask for what you want, and I'll make a decision.
Okay. So that maximum, where is he now? He's changed so many times.
Okay, you asked for a non-negotiated plea. Now you're asking for him to negotiate the plea.
Well, now I just was asking what he wanted. Because
Yep.
we had said several.
Okay, well, let me get started, and he's gonna tell you in a minute.
Okay, great. Your Honor.
State of Georgia versus Willard Kirkland Walker, 2021 CR 08227. DUI less safe, count 1, striking a fixed object, count 2. Mr. Walker is represented by Mr. Nathaniel Middleton. Mr. Middleton is present by video. Mr. Walker's in court. The state is represented by Mr. William Tipton. Mr. Walker, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand down. You're before the court on State of Georgia versus Willard Walker for DUI less safe and striking a fixed object. Mr. Middleton, what does your client plead to the offenses before the court?
We plead guilty.
All right, factual basis, please, and recommendation from the state, and then I'll hear the recommendation from the defense.
Yes, Your Honor. On May 22nd of 2020, Officer Santos with the Clayton County Police Department responded to a driver who hit a mailbox. It was determined the driver was the defendant before you, Mr. Walker. Mr. Walker hit the mailbox at that location belonging to a Miss Margaret, Margaret Sloan, Sloan, who attempted to make contact with Mr. Middleton. Upon arrival, the officer attempted to perform HGN. Mr. Middleton refused HGN. This is after seeing various clues that indicate intoxication, including slurred speech, red glassy eyes. Let's see. and the odor of alcohol. Upon making contact with Mr. Walker, Officer Santos requested HGN. Mr. Walker refused. Then he requested walk and turn. Mr. Walker refused. Then he requested one leg stand. Mr. Walker refused. Mr. Walker did not consent to implied consent. He was arrested for striking a fixed object, that being the mailbox belonging to Miss Sloan, and for DUI based on the totality of the circumstances. Your Honor, this is Mr. Walker's second DUI. He had a DUI subsequent to this, making it his third conviction over the course of the events took place over the course of 3 years. Out of Douglas County, out of Clayton County, 2021 out of Douglas County, out of Rockdale. Your Honor, state is requesting for count 1, 12 months to serve. State is requesting for count two, a consecutive 12 months of intensive probation. That would include all the regular DUI requirements. DUI risk reduction course, no drugs or alcohol, subject to random testing, substance abuse evaluation, and any recommended treatment. No less than two community support groups per week. 240 hours of community service, a $1,000 fine. Not weekly, bi-weekly testing, every other week, that is. That the defendant's license be suspended during the entirety of his probation. Nothing further from the state, Your Honor.
All right, Mr. Middleton.
Yes, Your Honor. With regards to what the state wants, we are willing to accept all of the conditions with the exception of, as I stated, the 12 months to serve. Before, the state was only offering at first 2 days, then 10 days, then 30 days. I don't understand why they're fluctuating between the number of days to serve. You know, it's not consistent.
3 convictions in 3 years.
Well, those it's over 10 years. It was 2 and 5, and the other was beyond the 10, so that shouldn't count at all. But we are willing to accept what the state has to offer with the 2 and 5, and that's pretty fast, head fast to the law. But 12 months would not be it. I think 30 days would be appropriate at this time, Your Honor. And we would ask that if Ms. Walker could serve those on the weekend, because he just got a job.
Bullshit.
And he's been unemployed since COVID. He's been trying to put ends together, and he's got a lot of bills. He doesn't have any kids, thank God. Right now, his kids are grown. But we think that we can do 30 days and take those on the weekends, Your Honor, and pay a fine. We'll be willing to deal with that without any problem, Your Honor.
I'm sure, Mr. Middleton, but Mr. Walker has had 3 lifetime DUIs. So the first one, even though you said that's outside the point of consideration, that to me, a DUI should shake you up enough to say, I never want to go through this again. And I don't care what's going on in your life. Everybody has something every day. If you slung a cat at 6 people and hit them, you probably would not want their lives in exchange for what you got going on, because everybody's got something. So the excuse that he was going through this, he was going through that, he was going through this. If he had sat home and drank and never gotten behind the wheel of a car, it would not be my concern. I would wish him well. I would hope he would get some help, but that would not be my concern. But for some reason, Mr. Walker doesn't mind drinking and getting out on the road. And then 2 in a very close proximity in the 5 days. And then when I asked, okay, I said, let's put you in DUI treatment court because that to me makes sense. You don't want to do the Clayton County treatment court because we want to be convenient for Mr. Walker. So, okay, I'm gonna let Mr. Walker do what's convenient because I feel like if you can get it to where it's easy for you to do, you will do it. Then y'all to go to Cobb, and for some reason, I don't know why, a previous lifetime DUI, this DUI, another DUI pending, they tell him that he doesn't need treatment. Now, I've never heard that. That to me is just crazy. But I don't, like I said, I don't know Cobb's metrics. I don't know what they do, what they measure. So now the ball's back in my court. Motion to revoke gets filed. I'm waiting to do the motion to revoke, Okay, we're here before the court for the motion to revoke. And then I get, well, Judge, he's done all these things. Well, first of all of them are from 2022. So I'm sure they're associated with some other DUI or something else that doesn't concern me. And then I get information about he's done 240 hours of community service from an organization that he headed that doesn't even exist anymore. So I just feel like I'm ill-used in this situation. And I don't know that Mr. Walker is taking seriously what is going on because there's tons of people who go through tons of things and they don't have not one DUI. When you fail to acknowledge the fact that you have an addiction problem, because most people, they're used to seeing Otis the drunk from the Andy Griffith show, who comes and he's laying down on the floor and then he'll get up and go lock himself in the jail and sleep it off. You don't have to be falling down drunk and not able to function to have a problem with addiction. You do have to make very, very reckless and inconsiderate decisions around your addiction. And Mr. Walker has made reckless and inconsiderate decisions around his addiction. At some point, we have so much technology now and so many new things that we could do that are alternatives to getting behind the wheel under the influence. But somehow we're not getting that. Like, you don't have to drink and drive. You can stay home and drink, or you can have someone else drive you. And for very little money comparatively, because this is not the age where you would have to call a limousine if you wanted to have a night on the town or be chauffeured around. You can call an Uber. But Mr. Walker was willing to risk other people's lives repeatedly, 3 times that we know of in his lifetime, 2 in 5 years that we know of. He was willing to risk lives because he's making reckless decisions. And so I'm going to sentence Mr. Walker on count 1 to 12 months to serve 180 days in the Clayton County jail.
So first we have to decide how much do we want to find out. And I come horizontally where it intersects with my grade line. I'm going to come straight down to where it intersects with my fuck around line. That there is going to tell me how much I have to fuck around to find out what I need to find out.
Balance will be probated for him to begin intensive probation, a risk reduction course, no alcohol or illicit drugs during the course of his probation. He's subject to random screens for alcohol and illicit drugs. He'll take a substance abuse evaluation and any treatment that is necessary. He'll do 2 community support meetings per week and report his attendance at those meetings. Those community support meetings must be for the cessation of addiction. 240 hours of community service, a $1,000 fine. He'll test at each report. Count 2 is 12 months to be served consecutively to complete the special conditions as ordered in count 1. And Mr. Walker will get an interlock device also once he gets his license back for the remainder of his probation.
And can he report at another date, not today?
Sure. What day would he like to report?
Your Honor, state would object to him having a later report date.
Yeah, I mean, I agree with Mr. Tipton because y'all have been on the calendar for this 5 months, 5 times. So if he hasn't gotten his stuff together in all of those times that y'all have been on the calendar for this, then it's just not, I mean, at least you should have anticipated something happening. So yeah, Mr. Walker will be taken into custody at this time. All right, Mr. Middleton, you'll get a copy of his sentencing sheet. Ms. Wright can send that to you.
And Your Honor, I would like to make sure that Mr. Walker is aware that if he has questions, he needs to talk to his attorney. He has attempted to speak to me just a
Yeah,
moment.
Mr. Walker, you can't speak to the state's attorney. He's not representing you. He's representing the state. If you need to talk to Mr. Middleton, he can come see you in lockup.
And for the record, Your Honor, may I say something?
Yes.
Yeah, if the, Mr. Tipton would, and if the court would go back and change some of the language that from the transcript, he called my name versus Mr. Walker's name.
I apologize for that. I'm looking at your name on the screen, and then all I see is state court OTB pod. So I was at all times when I intended information for the defendant, that was Mr. Walker. I apologize for saying Middleton, but I'm looking at the screen and his name is written out. And as I'm speaking, that is probably what I said. So my apologies.
Yes, that was also the state's intent, was to refer to the defendant as Mr. Walker each time it referred to the defendant. Once again, same situation with me and Judge Hayward. I've been looking at Mr. Middleton's name on the screen pretty much constantly during this hearing.
All right. So Mr. Walker can be taken into custody. Any questions he can ask his attorney. We'll get you a copy of the sentencing sheet.
Can I bring something else forward to the young?
Hold on. Don't take Mr. Walker back yet. Yes, Mr. Middleton.
Mr. Walker is on medication that he needs to take on a regular basis.
If you all provide the medication in the labeled prescription bottles and a copy of the prescription from his physician, Mr. Walker will be administered his prescriptions. You can provide it to the medical staff at the jail if you need an order from the court to allow them to give it to him. But generally, all they need is the prescription and the labeled bottle, the bottle labeled as it is as he purchases it.
If we can get that order, Your Honor, would save time, because I don't know I don't know exactly where. I've never been to his house, and I believe he lives alone.
Your Honor,
if somebody can provide his prescription, I mean, I can give a medical order that he's to get his medication as directed, but they do that anyway. But what I can't do is tell him what to give him, because I'm not a doctor. So he would need a copy of his prescriptions to be able to do that.
Yeah, I know, that's what I'm saying.
He has grown children, they can't get his medicine.
But he lives alone. But we can reach out to him. Is there any way we can have a breakout room with Mr. Walker after you get through?
No.
No. Okay, well, we'll try to do the best we can, Your Honor.
All right, thank you, Mr. Middleton.